pornography category, but most of them that have been captured are definitely questionable or come close enough to the acceptable use policy that we don't want them on our network.
So you actually have quite a prodigious collection of pornography, don't you, Mr. Martin?
No. Once the images are reviewed, HR is notified if necessary, or the images are deleted.
Okay. Have you ever made personal use of any of the images in this database, Mr. Martin?
Absolutely not, and that's offensive. I'd like to object to this.
I'm sorry, but it's quite relevant to the use charge. So this flesh reader system, you were running this during the SMOOT conference?
Absolutely. It's run at all times on our networks.
And therefore the system was acquiring all of the messages and filtering through flesh reader, and anything that had a particular percentage of fleshy hues?
Yes.
Was collected?
Yes.
Okay, so, and you admit that this system intercepted and stored the senator's emails and his photos?
I found out later that they did.
Okay. Did you use the filters? Did you personally monitor the output of the filtering system during the conference?
No, I did not.
So your use of that filtering system did absolutely nothing during the conference to prevent any misuse of your network?
Technically, no. It didn't stop at real
I'm sorry,
time.
yes or no? Did that system prevent misuse of your network during the conference?
Technically, no.
Thank you. And I guess there was no deterrent effect from the use of that system because you never told the attendees that it was being used, did you?
That's in the acceptable use policy.
Was the acceptable use policy distributed to the attendees?
I don't know. It's not my job.
Are you aware of anyone having notified or obtained any consent from any of the conference attendees?
Isn't it common sense that anything you send out on wireless is going to be read by everyone?
Objection, non-responsive.
Would you please answer the question?
That is an answer.
Are you aware of anyone in your organization having notified or gotten the consent of any of the conference attendees to have their traffic monitored by
3,000 people?
CMO?
No, I don't.
Yes or no?
I don't know. I don't think they did.
Okay. Earlier when you were asked about Mr. Bulette, you said you admired his work.
Yes, he writes very good articles.
More than admiring him, you've actually repeatedly sent him email, correct?
2 or 3.
2 or 3. Okay. Is it 2 or 3 or more? Do you know? Do you know how many emails you've sent him?
More than 1, less than 4.
Thank you for your precision. So, and in these more than 1, less than 4 emails, did you send Senator Gism's emails and pictures to the reporter, Mr.
Absolutely
Bulette?
not.
You didn't. So you claim you didn't send these emails. Let's move on and talk about your relationship with the senator. It's fair to say you're a longtime supporter of Senator Gism?
Formerly.
Formerly. In fact, you've worked as a full-time volunteer on all of his previous campaigns, have you not?
Not all, most of them between jobs as time permitted.
Okay, and you've regularly contributed to his campaigns?
10% like a good citizen, yes.
And that's because you support his views on moral purity and order. Is that not correct?
Yes, moral purity.
Indeed, you feel so strongly or felt so strongly about your support for the senator that you, during the 2000 campaign, got a tattoo with the words "Gism Forever 2000" on your left buttock. Is that not correct, Mr. Martin?
Proudly displayed it at some of his rallies to his opponents.
So I bet you were pretty darn disappointed when you saw these photos that were published in the Washington Compost.
Disappointed just like I am in the legal system.
The jury will disregard the slight to the judicial system.
So you were more than disappointed, weren't you? You were pretty darn angry, weren't you?
Yeah, I was a little angry.
And so you're glad now to see the senator's hypocrisy exposed, aren't you?
I wouldn't say glad. I would say that justice has been done through his own actions.
I don't think I have any further questions.
Good.
Any redirect?
Yeah, I have a few questions, Your Honor. Mr. Martin, so why didn't you look at these pictures during the conference?
Way too much to do. The hotel screwed up the network. There was too many computers trying to sign on. It ended up being a lot busier. Just had way too much on my plate. Didn't have time to actually look through any of the stuff that the program had collected.
So is it any good to keep pictures from the conference if the conference has already ended?
Absolutely. If at any time down the road I have a chance to look through the directory, we can tell which members were sending pornography. And even though we couldn't stop them during the conference, we can make sure that they're not invited the following year.
Okay. Did you send the pictures to Ryan Bulette?
No, absolutely not.
Thank you, Your Honor. No further questions?
Any additional cross-examination?
No, Your Honor.
Mr. Rome, do you have any more witnesses?
I don't. The defense rests.
Sir, you're excused.
Your Honor, that's my final witness. The defense now rests.
Thank you. The defense rests. Ladies and gentlemen of the jury, you've now heard all the evidence. What was going to happen next is you are going to be hearing closing arguments, first from the prosecution, then the defense, and if the prosecution likes to or desires to reserve a little time for a secondary close, he will have that opportunity. Once the closing arguments are made, I will instruct you on how to determine the facts in the case and the questions that are presented to you. You will deliberate, and then once you've been able to, if you are able to reach a verdict, we will reconvene at that time. But we'll move now to closing arguments with Mr. Bankston.
Thank you, Your Honor. We're moving fairly quickly this evening. I'm going to try and stick with that trend. Because I think this is a fairly open and shut case. The defendant has admitted that the software he installed did intercept Senator Gasm's, Jism's emails, that it was intended to do so, that it was intended to indiscriminately collect all of the traffic on that network, the conference network, not the internal network, and then to be passed through a filter that, among other things, collects innocuous images that would never raise any specter of liability. Of course, even if there were a specter of liability, no one on CMO's staff would know that, because they can't even identify what is legal and illegal content. There is nothing accomplished by this surveillance regime. They admitted that it did nothing to maintain the security of the network while it was running during that conference. It served no legitimate purpose, other, and this is not a legitimate purpose, to enforce the moral values of the provider. Now, the law is clear. Interception is a crime. And the providers do have a narrow exception that the court will instruct you on, such that they can work to maintain their service. They can work to keep the system secure and protect their property and their legal rights. But we're not talking about legal rights here. We're not talking about protecting their property. We're talking about them imposing their moral values on their users through comprehensive surveillance without any kind of notice or consent from any of the people being spied on. I think that if you were to accept what is going to be clearly the defense's argument, that a provider has the right to do this, then the exception swallows the rule. Where does it stop? If a provider dislikes arrows, can they filter for Arabic containing messages? If they dislike the color blue, can they filter for messages that contain that offensive color? I would say no. The law would say no. So clearly, the defendant has committed the crime of interception, and in particular has intercepted Senator Jism's emails outside the provider exception, which leaves us with the charges of use and disclosure. The defendant admits that his sniffer and flesh eater software combination, moral decency, intercepted and stored copies of the emails and photos of the senator. There's no evidence that anyone but the defendant had access to these photos other than the senator and his aide, Ms. Lovelace, who have both testified that they shared with no one else. And the defendant, the only person with access to these photos, is well acquainted with the reporter who then shortly after the conference published them. A reporter who refuses to deny that they were provided by the defendant. I think that's an open and shut case. Admittedly, it is circumstantial evidence. We do not have direct evidence of that disclosure. But as the court will instruct you, you must consider circumstantial evidence just as you must consider direct evidence. So in conclusion, I pray that the jury send a strong message to those segments who think they are above the law. Send a clear message that if you want to sniff someone's content, you better, and forgive my French, have a damn good reason, and convict the defendant of interception, use, and disclosure of Senator Newsom's emails. Thank you.
Mr. Ohm. And Mr. Ohm, if you would like to use a microphone, your comments will actually appear in the record.
Thank you, Your Honor. I have no idea why the prosecution just talked about pink elephants for 5 minutes. It's as inexplicable to me as it is to you. The last point that I want to start with the last point that he made, which was that he used these words circumstantial and direct. And as the judge is going to instruct you, two of the crimes that my client is accused to have committed include the use and the disclosure of this information. The use and the disclosure. My client has testified that he did not use these photos. He did not disclose these photos. There is no direct evidence. The reporter didn't testify at all about who his source was. There's simply no direct evidence, and what the prosecution basically asks you to do is pile inference upon inference upon inference to say that the use and the disclosure were his. So that leaves us with the interception charge, which is the charge that the judge is going to describe the elements to you. And what I want to say about that is, remember the ancient maxim, a man's home is his castle. And what does that mean? You all have familiarity with that. You are allowed to protect your home. You are allowed to protect your property. You're allowed to protect your rights. If you're in your home, you have special and recognized rights and protection. And so the question is, for you, the jury, is the network your castle? And luckily, the judge is going to instruct you that the law has already supplied an answer to that. This law says that you are allowed to do monitoring if it's a necessary incident to protect your rights and property. The judge isn't going to tell you what those terms mean because we trust you, the jury, to divine the meaning of that. What does it mean to say that you are allowed to protect your rights and property? Well, there's two competing views that are being presented here. The government wants you to believe that those words, rights and property, have a cramped, narrow, constrained view. That rights and property, the idea that your network is your castle, is something that's limited to a tiny list of things. And don't be distracted by comparisons to Arabs in the color blue. I think you well know that that's not what we're talking about in this case. So what did my client, what did Mr. Martin do in this case? He was scrupulous. He was protective. He knew that this is what his employer wanted him to look for. He only looked for pornography. Now, granted, sometimes this program didn't work perfectly, but it did work a lot of the time. And there were images in there that reflected pornography. He was scrupulous to make sure that immediately images that weren't detected as pornography were erased. He never saw those images. His goal was to accomplish what his boss and his boss's boss and his organization set out to accomplish. What would the government have him do? What would the government have him do in this awkward situation? The government really puts forth maybe three possibilities. Number one, he could go to the important people, the people with whom they have very delicate relationships, like the senator, and he could ask him for permission.